So let's start with the Indian Contract Act. We'll be revising few of the concepts of Indian Contract Act. First is your nature of contract. So consider this as to be unit 1's concept, and this is all combined concepts. We'll be just revising all the concepts. You can go through this PDF for quick revision. Now, nature of contract. They have given us an example that A sells car to B for payment of price. So A is under the obligation of giving the car and he has the right to receive the payment. Whereas B, he will be under the obligation of making the payment and receiving the car. Okay, right to receive the car on payment, and he will be under an obligation to make the payment. So your above situation talks about formation of an agreement. A and B will make an agreement. Agreement is the essential of a contract. An agreement is the result of a proposal by one party and its acceptance by other, with the consideration forming the foundation of any contract. So if A and B are entering into a contract, that means they are entering into an agreement. An agreement is a result of a proposal that is done by one party and being accepted by the other party. For this, consideration should form a part of contract. Okay. Therefore, such an offer and its acceptance gives rise to right and obligation against each other. So when offer is given and when the offer is accepted, this gives rise to right and obligation against each other. An agreement, in order to be a contract, must satisfy the conditions as specified in section number 10. So if an agreement wants to become a contract, what all things it should specify? It should comply with all these conditions. What are the basic requirements? Made with free consent, no coercion, undue influence, misrepresentation is there. Agreement should be between parties competent to contract. We have a separate section for this, so we will be learning competent parties also. For a lawful consideration, the consideration that you're paying should be lawful and with a lawful object. The intention also should be lawful. Are not hereby expressly declared to be void. You should not get into any agreement which is expressly declared as void. Okay, since section number 10 is not complete and exhaustive, so there are certain other sections which also contain requirements. So other than this, there are also some requirements, right? So what all requirements are there which are not given in section number 10? There should be two parties to contract. Intention should be to create a legal relationship. Two parties are important because one will be your offering party and the other will be your accepting party. It should have the intention of creating a legal relationship. Then you should be fulfilling all the legal formalities. Certainty of meaning should be there. Possibility of performance, you can be able to perform that promise. If you're not able to perform that promise, do not enter into such agreements or contracts. Okay, now, what is the meaning of offer proposal? We saw in unit number 1. As offer is the starting point is in making the agreement, an offer is called as proposal. So, when we give an offer, that is the starting point of the agreement, that is called as proposal. Thus, a valid offer, the party making it may express his willingness to do or not to do. So, if you are making a valid offer, the party who wants to accept the offer, they will show their willingness to do the contract or not to do that contract. Okay, law defines the term proposal as when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtain the assent of the other to such act or absistence. So, one party may say, I will do this thing or I will not do this thing. When they show their willingness that I am ready to do this or I am not ready to do this, that means I am ready to pay you this much of salary. So, this is the offer done by company. Abstaining from not doing anything, company will say we will not defame you, you can sell your products, but for this you have to give us 5 lakh rupees. So that is an also offer that we are not going to blame you or we are not going to stop your business. So that is also an offer. Okay, with a view to obtain the assent, with a view to get the concern from the approval from the other party to such act or absistence. They will say, okay, you give me salary, I will work for you. So that is one act they are going to do. Or they will say, okay, you give me 5 lakh, I will not open the same business in this area. So that is absistence, so not doing anything. Okay, I hope this point first one is clear. Offer. Next is essential of offer or proposal. So what all things are essential? Two parties, offerer and offeree. Expression of willingness, you should show your willingness to do something or not to do something with a view to obtain the assent of the party, and you are doing this to get the approval of the other party. Okay, Modes of offer, it can be written or it can be oral, or by your conduct, by your behavior also, you can say that we have made an offer. Okay, you ask someone to like, if you want, you have displayed the products on the road for sale, so that is by your conduct you are showing you are making an offer to sell these products. Okay, you're not writing somewhere that come and buy the products, or you're not saying them verbally, you have just kept your products there, people will come and see, so that is by conduct. Or by omission or absistence, by not doing something also, we say that we are offering you, we offered you that I'm not doing this thing, you can go ahead with that work. Okay, offer can be of 5 types: general offer, counter offer, standing offer, specific offer, and cross offer. So all these type of offers are there, you can refer them in depth, and summarized way is given over here. General offer made to public at large, and anyone can accept by performing the desired act. I am having a cell phone shop, so that is a general offer to the public at large. Okay, then your special offer is there. Offer made to a specific a certain person and can be accepted only by that specific person. If I'm making an offer to only one person, that is a specific or special offer. Cross offer, two parties exchange identical offers in ignorance of each other's offer at the same time, it is not binding. When two people are giving the identical offer, so that is cross offers, but they were not aware that we are giving the same type of offer, so it is not binding on anyone. Counter offer, offeree offers to qualified acceptance of the offer subject to modification and variation in terms of original offer. Counter offer amounts to rejection of original offer. So if I am offering to pay 5 lakh to an employee, right, and the person says I want 6 lakh, so if we are settling down at 5.5 lakh, so that is a counter offer given, and my offer, original offer of 5 lakh is rejected. Only 6 lakh offer is open now. If I want, I can offer a new one and I can tell, let's settle the deal at 5.5 lakh. So that is a counter offer given. Okay, standing, continuing, or open offer. An offer of continuous nature which remains open for acceptance over a period of time is called as standing or open offer. Open offer to buy any of the cell phone for 15,000 of this brand, and what is the variation given. So that is an open offer given to everyone. It is open for everyone. Whenever you want, you can come and buy. You see some exhibitions are there, so that is also an open offer. Whenever you want, you can buy that product. Like, it's an open offer for everyone. Okay, clear everyone? Let's go ahead. Some important case laws they have given us. Carlyle versus Carbolic Smoke Ball Company. We have seen this earlier also. In the famous case of Carbolic Smoke Ball Company, advertised in several newspapers that a reward of euro 100 would be given to pay any person who contracted influenza after using the smoke balls produced by the Carbolic Smoke Ball Company according to printed directions. One lady, Mrs. Carby, used the smoke ball as per the directions of company, and even then suffered from influenza. So they said, if even though after using the smoke ball, if you suffer from influenza, you can come to us, we will give you compensation. One lady, Carlabil, Mrs. Carly, suffered from influenza even after using the smoke ball. So here, held, she could recover the amount. She could recover the amount because even after using the smoke ball, the influenza happened. Influenza means the viral or the infection has happened. Okay, so you can claim the damages. Clear? Now, it was an open offer to everyone. Still, she accepted the offer and she came for resolution. Next is your Lalman Shukla versus Gauri Datta. Gauri Datta sent his servant to Lalman to trace his missing nephew. He announced that anybody who traced his nephew would be entitled to a certain reward. Lalman traced the boy in ignorance of this announcement. Subsequently, when he came to know of the reward, he claimed it. So, Lalman, Gauri Datta's nephew, gone missing. Okay, and she sent her servant Lalman to go and find him. So, Lalman did not know that if Gauri Datta's nephew is brought back, she is going to pay, you can say, around 100,000. Okay, He was not aware that if I go and give back Gauri Datta, her nephew, so she will be giving me around 1 lakh rupees. So he came, he brought back the nephew and he said, now I have seen somewhere that you are giving reward. Now give me the reward. Held, he was not entitled to reward as he did not know the offer. He did not know the offer. He just brought back the nephew. He was not aware that there is an offer going on. If I bring back the nephew, I will be given 1 lakh rupees. Okay, so here a proposal is complete only when the offer is accepted. The person has knowledge that this offer was made. In the Lalman's case, the defendant's nephew absconded from home. Plaintiff, who was defendant's servant, was sent to search the missing boy. And after the plaintiff had left in search of the boy, the defendant announced a reward of rupees 501 to anyone who might find out the boy. Plaintiff, who was unaware of this reward, was successful in searching the boy. Mr. Lalman did not know that this offer is going on. Still, he searched for the boy. When he came to know of the reward which has been announced in his absence, he brought an action against the defendant. He said, I have got to know that you are going to give 501 rupees of reward. Now you give me the reward. It was held that since plaintiff was ignorant of the offer, plaintiff did not know the offer, then and brought back the lost boy, he did not accept the offer because he was not aware of the offer. How he will accept it? Therefore, he was not entitled to claim the reward. He will not get the reward. Okay. Next on this type of offers we have Bolton versus Jones. Bolton had taken over the business of one Brocklehurst with whom Jones had previous dealings. Jones sent an order of goods to Brocklehurst, which Bolton supplied without informing Jones that the business had changed hands. When Jones found out that the goods had not been from the Brocklehurst, he refused to pay them and was sued by Bolton for the price. Now what happened? Brocklehurst had an agreement with Jones and he had to provide some goods to him. Okay, now he has supplied the goods, but instead of Brocklehurst, who supplied the goods? Bolton, because Brocklehurst has sold the business, had sold the business to Bolton. Now Bolton, what he did? He provided the goods. Now after Jones came to know that the business has changed the hands, he said that I will not supply you with the money. Bolton said, how you will not give me the money? I have supplied you the goods. Now you are required to give me the money. So what Bolton did is he sued for the price to Mr. Jones. He said, even though you did not know that I am the owner of this particular thing, you have received the goods, so now you have to pay me the money. Okay. Jones is not liable to pay for the goods. It is rule of law that offer made to a specific or a certain person can be accepted only by that specified person. So if the offer was made only to Brocklehurst to give the goods, Bolton cannot supply it because that offer was specifically to Brocklehurst. Jones was having dealings with Brocklehurst earlier, not with Bolton. So why would he go into any agreement with Bolton? He has given an offer to Brocklehurst. See over here. They have given it over here very clearly that sent an order for goods to Brocklehurst. So it was given only to Brocklehurst. So Brocklehurst is only going to supply. Bolton will not supply. Okay. So this was a specific offer. That's why Jones is not liable to pay anything. And the court may also tell them to return the goods to Brocklehurst or the Bolton. Now here, next is your difference between offer and invitation to offer. They have again given us a case law. Let's see with the case law. So in Harvey versus Facey. In this case, Privy Council briefly explained the distinction between an offer and an invitation to offer. In the given case, plaintiff through a telegram asked the defendants two questions. Namely, will you sell us bumper hall pens and telegraph lowest cash price? Okay, so they asked for, can you sell us bumper hall pen and what is the lowest cash price you are going to take? The defendants replied through telegram that the lowest price for bumper hall pen is 900. Okay, give me 1 second. So the defendants had replied that the lowest price that they can offer for the bumper hall pen is going to be 900. The plaintiff sent another telegram stating we agreed to buy bumper hall pen at 900. However, the defendants refused to sell the property at the price. The plaintiff sued the defendants, contending that they have made an offer to sell the property at 900 and therefore they are bound by the offer. Now, what there happened? They said, okay, we agree for 900 rupees, 900 for one ball pen. Okay. However, the defendants refuse to sell the property at the price. Defendants are saying now we won't be selling it because that is the lowest price, and you are agreeing at lowest price. We want it somewhere more also. Plaintiff sued the defendants, contending that they had made an offer to sell the property at 900 and therefore they are bound to accept the offer. They are bound by the offer. Held that mere statement of lowest price at which the vendor would sell contained no implied contract to sell the person who had inquired about the price. Now, here what has happened? A company is going to sell the products, right? A company is going to buy the products from B company. B company, A said give us the lowest price quotation. He said we will give you 900 as the lowest. Now they are saying if you give us 900 as the lowest, we are ready to accept at 900. But if you are just mentioning the lowest price, that does not bind you with that offer. It is not compulsory to sell at 900. You are giving a minimum price. You can also ask them for 1000, 1100, any price. If B is getting another offer which they are offering for 1100, what he will say, okay, A, I don't want to sell you, I will sell it to Mr. C who is going to offer me rupees 1100. Okay. So here giving the minimum price does not bound you by that particular contract, by that particular offer. Okay, I hope this is clear. Great. Now, your next case law is Macpherson versus Apanna. The owner of the properties has said that he would not accept less than 6,000 for it. So, it was held that this statement did not indicate any offer but indicated only an invitation to offer. So, if I am selling something, owner of the property says that I can accept minimum 6,000, like not less than this I will be expecting, maximum I want is 6,000 rupees. So if you are quoting some maximum like a minimum price that you want, like I want 6,000 minimum, not less than 6,000 will work. So this is an invitation to offer. Then we have Harris versus Nickerson. An auctioneer advertised in the newspaper that a sale of office furniture will be held on a particular day. Plaintiff Harris, with the intention to buy furniture, came to a distant place for auction, but the auction was cancelled. It was held that plaintiff cannot file a suit against the auctioneer for his loss of time and expense because the advertisement was merely a declaration of mention to hold auction and not to sell it. When we are doing an auction, it is just an offer that we are making. We are not saying that we are going to sell it to you right away. This is just an auction. Here offer to sale is not there. Okay. So auctioneer Nickerson does not contract with anyone who attends the sale, and auction is only an advertisement. We go to auctions, exhibitions, so that is only an advertisement. It is not compulsorily that you will be buying the products or they will be selling you the products. Okay. Now, next case law that we have is Pharmaceutical Society of Great Britain versus Boot Cash Chemist Limited. Goods were displayed in the shop for sale with the price tag attached to each article and self-service system was there. Our customer selected the goods but the owner refused to sell. In this case, it was held that display of the goods along with price tag merely amounts to invitation to treat there, and therefore if an intending buyer is willing to purchase the goods at the price mentioned in the tag, he makes an offer to buy the goods. Thus, shopkeeper has right to accept or reject the same. The contract would arise when the offer is accepted. Hence, there was no contract and customer had no rights to sue the owner. So now we go to a medical shop or a grocery store. We see there are n number of products kept over there. They are for sale. They are just kept as a display, right? If you are willing to buy this, you can go and tell them I am willing to buy this. It is on the owner. If they want to accept it, they will accept it, or they can reject also. Okay. Now, next is your rules as to valid offer. If you want to make a valid offer, what rules are there? Intention to create a legal relationship. You are working because you want to create a legal relationship. Then we have certain, definite, and not vague. Your offer should be certain, definite, and it should not be vague. Express or implied, the offer should be express or implied. Different from invitation to offer. Your offer should be different from invitation to offer. Offer must be communicated, must be conditional. No term of the non-compliance amounting to acceptance. Any non-compliance will, no term of non-compliance will be amounting to acceptance. You should not write that if you do not comply with this, the offer will be considered as accepted. These conditions are not to be kept. Okay. Then we have your acceptance. Sorry. Now, person to whom the proposal is made signifies his assent thereto. Proposal is said to be accepted. When the offer is made to Mr. A and Mr. A approves it, that time you will say the proposal is said to be accepted. Okay, clear? Okay, let's go ahead. Next is acceptance of an offer. General rule, offer can be accepted only by the person or the person to whom it is made. If I am making a specific offer will be there. Like if I am making a general rule, general offer that I have displayed the products in the shop. So anyone who has the money, they can come and buy the products. Okay, so that is a general rule. Specific rule, specific offer accepted only by that definite person or particular group of person to whom it has been made. So you see, when you will be a chartered accountant, you will be asked to apply for as a tender for doing the statutory audits. For audits of banks, etc., you can make the special offer. So you can do the audits, like chartered accountant can do the statutory audit of a bank, but a CS firm, like company secretary firm, they can't do the audit of a statutory audit of a bank, right? So here the specific offer is given only for the people who are working in that area. If road construction is there, doctor cannot give the contract, or doctor cannot offer that I will construct the road. Only contractors, civil engineers, civil contractors will be saying that we can offer to construct the road. Okay, so that is a specific offer. Particular group of person only can make that offer. Then you have your general offer, accepted by any person by complying with the terms of offer. Anyone who is having the money, they can go and buy the product from the shop. So that is a general offer. Okay, one is general rule, what is applied for accepting the offer. Other is your general offer. Okay. Legal rules for valid acceptance, absolute and unqualified. If you are accepting something, you have to give the absolute acceptance, and unqualified, you can't give a condition. Communicated to offerer, the person who has offered you, you have to communicate them in prescribed mode. If they say in oral ways or written ways or by a sign, you have to do it that way. Time limit, they will give you some time limit that in 5 days you have to accept this offer. Before the lapse of offer, you have to accept that offer. Okay. Now, here I will not take much of your time with the case laws. This you can just go through the PDF, and we will be just discussing the concept over here. Okay, seeing that we need to cover more of the syllabus in the given time. Rules for communication of offer and acceptance. For valid offer and acceptance, offer must be communicated to the offeree. The person who is being offered, they have to listen to the offer. Offer should be communicated to that person. Acceptance must be communicated to offerer. So if you are accepting the offer, you have to communicate to the person who has offered you this particular thing. Okay. Now, when communication of offer is complete. Communication of an offer is complete when the knowledge is received by the person who has made the offer. Like if A is the offerer, I'll take it over here. A is the offerer. He should be given the communication that B has accepted it. When it comes to the knowledge of the person to whom it is made, right? When it comes to the knowledge of the person to whom it is made, when B comes to know, okay, this offer is done. So that time your communication of offer is complete. Okay. either by word spoken or written, or it may be inferred from the conduct of parties. You can also say by the conduct that okay, they have listened the offer. If I was selling, I you might have seen on the roads that they sell the products by using a speaker, and they say in the mic that we are selling this product for 200 rupees. So they use a mic, etc. So that means they are doing an offer, and that you are passing by that road and you might have heard this. You are a person who has the hearing ability, so they will be considering by your conduct that you have heard the offer. Okay, that time communication of offer is complete. It is not accepted, acceptance is not completed, but you have heard the offer. Offer is has reached to your brain or your ears that you have heard about it. Okay, clear? Let's see the next one. It's about here. When is communication of acceptance complete? Now your acceptance, when it is complete, as I told you, A has given an offer to B, and B in or has accepted that offer. So when we will say that acceptance is complete, when can I say that acceptance is complete? As against the proposer when put in course of transmission to the proposer. This person A has proposed. When B sends a approval by a letter, so when he gets to know that letter has been posted on 1st of June, right? So when the letter has been posted, that day will be considered as your communication or completion of the acceptance. As against the acceptor, when it comes to the knowledge of proposal, when A will receive the letter is received on 4th of June, so that time it will be complete for B, and on 1st of June when it is sent to Mr. A, that time it will be completed for A. Okay, when you send the letter to Mr. A, what A will consider, okay, I have got the acceptance. But for Mr. B, when it reaches the hands of Mr. A, when he sees the letter, that time you will say that the offer is completed, or the communication of acceptance is completed for Mr. B. He will say, okay, now I can say that I have accepted that offer. Okay, now communication of acceptance by post. So if I gave you an example that we are doing it by post, we are sending the acceptance by post. So what all things will be there when it is related to acceptance by post? Let's see. As against the proposer who has proposed that particular agreement, where the letter of acceptance is posted. I told you, when you put the letter into post office service by speed post, you send that receipt that okay, I have sent this receipt to you. I am sending a picture of the courier service charges that have been paid, and the acceptance by the courier person that okay, this offer is sent, or that letter is sent, parcel is sent. That time you will say that proposer will consider that acceptance is done. But when I am accepting, when the letter reaches the proposer, that time the acceptance is done. A said to B, now I want to buy 100 bags of wheat, right? A has sent this offer to B. Now B, what he does, he accepts and sends a letter. He sent the letter on 14th of June, right? So A will think that this is the date of completion of acceptance. When the letter is posted, here it is posted only. But letter Mr. A, reaches Mr. A on 18th of June. So for Mr. B, the acceptance will be 18th of June, and for Mr. A, the acceptance will be on 14th of June when the letter is posted. Okay, are we clear till here? Great. Acceptance over telephone or telex or fax. Offer is made by instantaneous communication, contract is completed. When you offer something and they accept it immediately, that time the contract is complete. When the acceptance is received by the offerer, the contract is made at the place where the acceptance is received. Okay, so when you on call confirm that okay, I am willing to do this product, or I am willing to buy this product, sell this product, so that is where your acceptance is completed. Next is when revocation of offer and acceptance is complete. If I revoke the offer and acceptance is already complete, so in that case, what are we going to do? as against the person who makes it when you put it into transmission. When as against the person who makes it, the person who is sending it, B rejects the particular offer. He says that I don't want to buy the products, I am rejecting your offer. So if you are rejecting the offer, the day you send the rejection letter, that day it will be considered for the transmitter that this offer has been rejected. Okay, I'll give you an example. Ravi Ravi is selling some products to um, Kishan, right? Now Kishan says that I don't want these products, so he sends a letter of rejection. Write it over here. Letter of rejection. A letter of rejection is posted on 10th of June, right? So for Kishan, the goods are rejected on 10th of June, right? But as against the person to whom it is made, to Ravi, right? When it comes to his knowledge, Ravi receives letter on 15th of June. So for him, the goods will be cancelled, or the offer has been rejected on 15th of June. For Kishan, it will be rejected on 10th of June. For Ravi, it will be rejected on 15th of June. So this is vice versa. This is opposite of when it was for offer of acceptance, when it is completed. Okay, it is completely opposite of it. Now, when a proposal can be revoked or acceptance can be revoked. Proposal may be revoked at any time before the communication of its acceptance is complete against the proposal. Before you accept the proposal, you can revoke it, you can reject it. Acceptance may be revoked at any time before the communication of acceptance is complete against the acceptor. Before you give the acceptance, like I told you, like the in the previous example, we saw that here the acceptance reaches Mr. Here the acceptance reaches Mr. A on 18th of June. So if I want to revoke it, I have to revoke it before this 15th of June. Sorry, 15, 16, 17. I have these days to revoke it. I can do it on call. Before he receives a letter, I can tell him, no, I don't want to accept the products. I want to revoke this contract. So before receiving that letter by Mr. A, I have informed that I want to revoke this particular acceptance. Before the acceptance reaches, I will tell him, you will receive the acceptance letter on 18th, but now on 16th of June, I am telling you, I don't want this offer. I don't want this particular contract, so I am rejecting it before he receives the acceptance. Okay, clear everyone? Great. Modes of revocation, how we can revoke an offer. No way, notice of revocation, I can write a notice. Lapse of specified or reasonable time. I was to accept the offer in 10 days, but I did not accept the offer in 10 days, so time has lapsed and the offer is revoked. Death or insanity of parties. I had given an offer to Mr. A and Mr. A died before accepting it. So here you can say the offer is revoked. Non-fulfillment of condition of offer. If I am not fulfilling any condition, like it was about to rain and then only the crops will be sold. It did not rain for the entire year, so the crops will not be sold. Then we have your counter offer. Okay, clear? So let's get to the next part of our contract act, which is consideration. So we know that consideration is very much important. It is rule of law, no consideration, that means no contract. What is consideration? When at the desire of promisor, promisee, or any person has done or abstained from doing, or does or abstain from doing, promises to do or abstain from doing so, such an act or absistence of promise is called consideration for the promise. So in our simple words, if I tell someone to decorate a building for me, right? I give my I give my house contract to an interior decorator. So they are doing some activity for me, right? So they have promised me that they will be doing that activity for me.
so they have done something. Or if I tell someone not to destroy my house, so I am abstaining them from doing something. If I tell another teacher to not copy my videos, so I am telling them to not do something, I'm abstaining them from doing something, right? When the promisee or any other person has done or abstained from doing something, does or abstain from doing something, he's doing that thing or is abstaining from doing something, or they make a promise that okay, I will not share your videos without your permission, I will not use your content without your permission, so that is also a consideration that I'm getting. For this I will be paying some money, but this is the consideration. I am not getting any money consideration, but I am getting that my videos will be uploaded only on my channel or the academy I'm associated with. Okay, simple and basic example. Such an act or assistance or promise is called consideration for the promise. So you get the act done or you get the assistance, like no, they are not going to perform that act, that is also a consideration. So what are the requirements of valid consideration? Let's see. Move at the desire of promisor. If promisor says don't do this, so they are not going to do it. Past, present or future. Your consideration can be past based, present based, or you can give a future consideration. Promisee or any other person can give the consideration. Adequacy of consideration. It should be sufficient, adequate consideration. Not be unlawful, immoral, or opposed to public policy. I can't tell someone go and murder this person for me. That is an unlawful consideration, immoral consideration that I'm asking for. Okay, so that will not be valid. Other than promiser's existing obligation. If I have some money pending with someone, this consideration, like as some money is pending, I have some money due from Mr. A, and now I get into a new contract. So the money that is due from Mr. A, that is a separate consideration. This is a new consideration, a new contract I'm entering with Mr. A. R has some transactions with A where A will be paying 50,000. Now I get into a new contract with A which is of 1 lakh rupees. Okay, so if I am getting into a contract of 1 lakh rupees, I will not adjust this amount or add this amount over here. Okay, that is a different one from promiser's existing obligation. Okay, the consideration should be real and not illusory. Okay, it should be a real consideration. Next, what we have is your suit by a third party on an agreement, doctrine of privity of contract. Right, so the general rule is a stranger to a contract cannot sue. So if R and A have got into a contract, B, who is a stranger to contract, they cannot sue A for the money. They can't say now give me the money or give Mr. A the money. Who are you? You are no one related. Stranger to a contract cannot sue. Okay, but there are some rules where stranger to contract, there are some exceptions. They can be a party to contract, they can sue. Okay, suit can be filed by a third party in following circumstances: when it is a trust, acknowledgement of liability by estoppel, covenant running with land, like if some covenant is there running with the land, contract by agent, agent can ask for in on behalf of principal, assignment of a contract, if contract is assigned to you to recover the money, that time, family settlement is there, that time also third person can sue, they can file a case against the people. Okay, next is contract without consideration. Some contracts will be valid without consideration. They will be enforceable. But what are the conditions? Agreement made on account of natural love and affection. Father gives some gift or a contract, does a contract with the son. So that is a natural love and affection kind of thing. Promise to pay time barred debt. You make a promise that I will be paying this debt which was time barred. Promise to compensate, you give that, you give a promise that we will be compensating. Completed gift, bailment is there, that is also a contract. Here you are just keeping the goods with you, you are not being the owner of that goods, still that is a valid contract. Charity, that is also a contract. Donations we do. Agency business is also a contract. Okay, now, competency of parties. Parties eligible to make the contract. Which parties will be eligible? Parties who are major in age, who are of sound mind. Person who is a major in age is of sound mind and not otherwise disqualified from contracting. Law has not disqualified this person from contracting. These people only can get into contract. Okay. Now, laws relating to minors agreement or position of minor. Agreement is void ab initio. If you get into any agreement with minor, that is going to be void ab initio. Okay. No estoppel to plead on minority. You can't say that we have entered into a contract with minor. Earlier it was said if you are entering into a contract with minor, that is void ab initio. Now you can't take the help of it. Minor can be admitted to the benefit of partnership. You can admit the minor in the partnership business only for the profits. Okay. No ratification on attaining majority. Your ratification will not be done when you have attained the majority, because that contract was void ab initio. Now how you will ratify it? In case of supply of necessary, claim to be reimbursed from property of minor. If you are supplying necessaries like food, clothing, shelter, you are giving to minors, then from minors property, minors estate, you can ask for money. Contract by guardian under exceptions are valid contract. If guardian enters on behalf of minor, that time there are few exceptions where the contract will be valid. In case of fraudulent representation of age, a minor can plead his minority but required to return the benefit. If you have fraudulently said that I am of major age, like you get into a contract and you say that, oh, I am not 17, I am 19, so I can enter into that particular contract. Then if you have entered fraudulently, if you have taken some benefits, if it is caught by the government or by any other person, then you can plead that I was minor, but you have to return back the money. You can't keep the money. The benefits that you have arrived from that money, from that contract, you can't keep it with yourself. Okay. Now, case laws, you are going to read it because that will take a lot of time if we cover in the marathon. Person who is usually of unsound mind but occasionally of sound mind can be considered as sound mind and can make a contract when he is of sound mind. If sometimes you are of unsound mind and sometimes you are of sound mind, when you are in sound mind, you can get into a contract. Person who is usually of sound mind but occasionally unsound may not make a contract when he is of unsound mind. When you are not unsound, you can't get into a contract. Simple basic thing they have explained. Now, position of agreements with persons of unsound mind. If we enter into contracts with of unsound mind people, what is the position? When he is of unsound mind, cannot enter into a contract. Contract entered during this is altogether void. Cannot be held liable thereon. So you can't hold that person liable for the liability, because that time he was of unsound mind. How he will act or how he will take the proper decisions? Okay. When he is of sound mind, he can enter into a contract and he is liable for such contracts. Okay. Next is position of agreements in case of person of permanently unsound mind. In case of idiot people, in case of permanently unsound mind people, what is the position of agreements? A person who is permanently of unsound mind cannot enter into any contract. Any agreement entered will be void and not liable thereon. Someone is completely of unsound mind. You, even though if you get into contracts with them, that is invalid. That is not valid. That is a void contract altogether. Okay. Now, if you get into an agreement with drunken, intoxicated person, a sane person who is delirious from fever or who is drunk cannot contract during such state, because he cannot understand the terms of contract, cannot form a rational judgment as to this effect of his interest. Now, if A enters into contract with B and B is suffering from high fever, right? Suffering from high fever. So can he take proper decisions? No, he is not in that state of mind. He is admitted in the hospital. He is under the prescriptions and under the medicines, etc. He won't be able to take a rational judgment, right? He cannot understand the terms of contract. So that time, if a drunken state person is there or a person is intoxicated, they have taken some drugs, etc. That time you can't say that this person is eligible to get into a contract. Okay. I hope the position of people is clear to you people. Now, there are some people who are disqualified. Let's see who are those. Statutes disqualify certain persons to enter into a contract. Which people are disqualified? Contract by such person are void. So, if you enter into a contract with people who are disqualified by law, then your contract will be void. Okay. Who are these people? Alien enemies. India has alien enemies with Pakistan, China, foreign ambassadors, convicts, people who have convicted something, insolvents, corporations, etc. Whatever law will specify, these people, if law has specified as disqualified, you can't enter into a contract with them. Okay. Next that we have is, after the parties we have considered, next will be a free consent. Let's see what is free consent. Two or more persons are said to have consented when they agree upon same thing in the same sense. When people are agreeing on same thing in the same sense, that time you can say you have your free consent, because I am understanding that I want to sell the classes, and you are also understanding that ma'am will be delivering us the classes. So this is the same understanding, same thing, same sense we are having. Okay. In absence of consent, agreement is void ab initio. If there is no free consent, then the agreement is void ab initio. Clear? Now, this was about concern. Let's see what is free concern. Concern is said to be free when it is not caused by. Your concern will be considered as free concern when it is not caused by. Not caused by what things? It is not caused by coercion, undue influence, fraud, misrepresentation, or mistake. Okay. When coercion, undue influence, fraud, or misrepresentation or mistake is not involved, that time your consent is free. Now, what are all these things? We will be seeing now. Agreement caused by coercion. An agreement is said to be caused by coercion if there is committing of any act which is forbidden by the Indian Penal Code. You put someone on the gunpoint and tell them, do this work for me. So that is your forbidden contract. You can't get into such contract. Threatening to commit any act which is forbidden. You tell them, I will shoot if you don't do this activity. That is a forbidden thing. Then next is your, you tell them, if you don't do this activity, I will commit suicide. This is also a forbidden thing. Unlawful detaining of any property, threatening to detain any property. You are detaining the property, you are keeping the property under your control. You take someone's bike and tell them, I will not give you the bike until you go and do this activity for me. You go and deliver some intoxications for me. So you are going and delivering drugs for the other person, and he has taken your bike. You feel, I want my bike back. How will I go home, etc. And then you do that activity. So that is an unlawful retention. Or someone threatens you to unlawfully retain your products, your property. Okay, that is your agreement caused by coercion. Next is consequence of coercion. What happens if coercion is applied? The agreement is a contract in a contract is voidable at the option of party whose consent was so obtained. Now you have the option. You can leave the vehicle or you can go and deliver the intoxicated material. Now, if you go and deliver the intoxicated material, then you're making that contract as voidable. It is at the option of the person who is performing the contract, who is under the coercion, that they can enter into coercion or they can perform that contract. Okay. If you are giving the consent, okay, keep my bike, I will go and deliver the drugs for you. That is where you have made the contract as voidable. Okay. It is voidable at the option of party. If you want to perform, you can perform. If you don't want to perform, you can skip that contract. Okay. One second, let me fix the camera. Great. Undue influence. Yeah, so next we have is undue influence. Contract is said to be induced by undue influence when is undue influence seen? When relations subsisting between the parties are such that one of the parties is in a position to dominate the will of other, and the dominant party uses the position to obtain an unfair advantage over the other. When one of the party is trying to obtain the control dominance over the other party, that time the dominant party is said to be taking unfair advantage. Like sometimes our elder siblings try to take dominate us, right? And they try to take unfair advantage. So that is kind of undue influence. Simple basic example I'm taking. Someone is at a higher authority. They try to tell you that you need to deliver the goods at this place, or you need to do this thing. So that time also you will be considered as taking undue advantage of it. Okay, clear? Next is effect of undue influence. When an agreement caused by undue influence contract is voidable at the option of the party whose consent was obtained, contract may be set aside. Okay, so when undue influence is there, you can keep aside that contract. Next is your fraud. One second. Yeah. Fraud includes any of the following acts. Suggestion as to a fact which is not true. That is also a fraud. Like you don't give them the true facts of something. That is a fraud. Active concealment of a fact. You know about that fact. Still you are trying to conceal it. That is also a fraud. Promise made without any intention of performing it. You do a promise and you tell, okay, I'll do this for you, I'll completely agree with this, and I'll perform the agreement, but you don't do it, so that is also fraud. Any other act fitted to deceive. Act or omission as to law specifically declared to be fraudulent. You do some fraudulent activity, that is also considered over here. Now, by whom and when fraud, sorry, by whom and when fraud is said to be exercised. Fraud can be committed by any party to a contract which in his with his convenience or by his agent. So any person can do the fraud directly by an agent or by any other person of their convenience. Act when done with intention to deceive. Your act is done with an intention to deceive the other party or his agent to induce him to enter into a contract. When you do such fraudulent activity and make that person to get into a contract, that is also a fraudulent activity. You try to deceive that person. What is the effect of fraud? Your contract is voidable. There are remedies available. You can rescind the contract, you can cancel the contract, you have the option to perform the contract. You know the fraud is done, still you perform it, or you have the right to claim the damages, right? If fraudulently he promised you that I will be paying you the money, but he does not pay, so you can tell them to pay because you have known that this is a fraud. So you can ask them to pay. That is right to performance and right to claim damages. If fraud is done with you and you face any losses, you can claim the damages. Okay. Does mere silence amount to fraud? Yes, mere silence as to facts which is likely to affect willingness of a person to enter into a contract is no fraud. Like if it is likely to affect the willingness of a person, if you are silent and that person, if you speak up, they will not enter into that contract, that time it is not considered as fraud. Which is likely to affect the willingness of a person to enter into a contract, that time your silence is not considered as fraud. But there are few exceptions to this. Okay, that is not right now, so there will be some exceptions where it is the duty of a person to speak or his silence is equivalent to speech. Silence amounts to fraud. Like if A says that I want to buy a horse to Mr. B, he says that I want to buy a horse for riding, and A knows that B knows that this horse which he is selling, A says to B to buy a house, buy a horse, like he wants to buy a horse, and B knows he wants a horse for riding. Right? B knows the horse one is unfit for riding. Right? He knows that this horse one is unfit for riding. Still, he gets into the contract with Mr. B. Here, it was important to say something. Here, your silence has resulted into fraud. Now, if Mr. A writes this horse number 1 and something happens to Mr. A, B will be responsible because he did the fraud. Okay? I hope this example was clear. Okay, let's go ahead. Misrepresentation. When a person positively states that a fact is true when his information does not warrant it to be so. When you're giving some information that this is true, but actually that is not true, when you can't warranty that particular statement, that time misrepresentation is done. Where there is a breach of duty by a person without intention to deceive, which brings an advantage to him and loss to the other. When a party causes the other party to the agreement to make a mistake as to subject matter, when your subject matter is not clear, you are misrepresenting the facts. You are telling them, I gave you this example of the horse thing, right? So here you are not telling them the facts, you are misrepresenting. That is the case which will be covered under misrepresentation. What are the consequences of misrepresentation? The contract is voidable. What are the remedies available? You can rescind the contract, cancel the contract, or you can write to insist upon performance. You can tell that person, now you provided me a wrong horse, now give me a correct horse. Okay, that is also an option available. Yes. Next, let's go ahead. Now, so consequence of misrepresentation is that it's a voidable contract, and the remedies available is you can cancel the contract, rescind the contract, or you can insist upon performance of it. Mistake, when both the parties of an agreement are under a mistake to a matter of the fact essential to agreement, the agreement is altogether void. When both the parties have considered it wrong, like they have mistaken the agreement, that time you can say that this agreement is a mistake. Okay, and in that particular kind of agreement, that agreement will be altogether void in the initial phase only. When you have entered this agreement, you were not sure that this is a mistake done. So then when you get to know that there was misunderstanding, mistake is done on both the parties part, then you will say that this agreement is void. Okay, clear everyone? Let's go ahead. Let's see types of mistakes. So some can be mistake of law, like you misinterpreted the law. Mistake of law has happened. You understood different thing and the other person wanted to say something different. Law, in law it was written something. Mistake of Indian law, mistake of foreign law, we have discussed in detail earlier also in our regular class. Mistake of fact, there can be a bilateral mistake or unilateral mistake. One party has only understood it wrong or they have mistaken, that is a unilateral mistake. Bilateral means both the parties have taken the wrong meaning, they have mistaken the things. Okay. Now, bilateral mistake are subject to, are as to subject matter, can be as to existence. Like you understood that Mr. A is going to sell the car which is of black color, right? A thought I will purchase black color car, but in fact that black color car was already sold, right? So here B was talking about selling you red car. Okay, that is as to existence. That car is not existing, it's already sold. As to quantity, you have some confusion with the quantity. Then as to quality, you thought you will be getting A quality products, but you got B quality products. As to the price, you thought you will get 500 grams at rupees 200, but it was said that 200 is the price for 100 grams. Okay, or 200 grams, that is a different thing. As to the identity also you are confused, or as to the title, if you thought this belongs to Mr. B but it was actually belonging to C, so their title mistake can also be. This is a bilateral mistake. Then we have unilateral mistake, where only one party to the agreement is under a mistake. Only one person has misunderstood the thing. A contract is not voidable merely because it was caused by one of the parties to it, being under a mistake as to matter of fact. If only one party has thought of it as mistake, then it is a unilateral mistake and it is not voidable. You can perform this contract after correcting the mistake, but there are some exceptions also. What is the exception? Agreement is void where a unilateral mistake relates to identity of person contracted with or nature of contract. You thought you were going to buy the car, but you are instead going to buy a truck. Like the contract was of a truck. So there is nature of contract is mistaken. So that type of contract you won't perform. Otherwise, identity of person contracted is mistaken. You thought this is the partner of the firm, but he was not the partner of the firm. He was just an employee working over there. So in that particular case, unilateral mistakes will not be performed. Like that contract will not be performed. It is voidable. Okay, if you want, you can perform. Otherwise, you can skip that. It is actually void at the earlier stage only. But some people will think, okay, he's your employee, but he has explained everything nicely, so we can go with the contract. So that is also an optionable. Effect of mistake. Nature of mistake and nature of agreement. In bilateral mistake, the agreement is void. If bilateral mistake is there, both the parties have misunderstood, the agreement will be void. In unilateral mistake, as to identity of the person contracted with, agreement is void. If you have misunderstood the identity, you thought he is the partner, but he was not the partner, your agreement is going to be void ab initio. Then as to nature of contract, you thought you are buying car, but this person was going to sell you truck, so that time your agreement is also void. As to any other matter, the agreement is not void. Okay, in these cases it is void, but in other matters, as to quality, quantity, etc., any other matter is there, then it is not void. Remedies under mistake. What are the remedies available with us? Obligation to aggrieved party. He must restore any benefit received by him under the contract to other party from whom the benefit had been received. If you had gotten into a contract with mistake and you thought you are going to buy a car, but the person has contracted to sell the truck, you gave the advance payment also for the car. Now when you get to know about the mistake, the money you have paid for car is to be recovered back. Okay, that is obligation of aggrieved party. What is obligation of other party? The person to whom money has been paid or anything delivered by mistake must repay or return it. If some obligation is there on the other party, he has used that money, it is the duty to repay or return back that money. Okay. Great. Now let's see what is the difference between coercion and undue influence. Nature of action. Coercion involves physical force. They can put you under the like they can put you hold on the gunpoint. In undue influence, it is mental pressure, immoral or mental pressure is done. Here involvement in criminal activity will be there in coercion, mostly that is relating to criminal activities which is forbidden by Indian penal code, and here no such illegal activity is committed or a threat is given. Okay, you don't give a threat or commit a illegal activity in undue influence. You just try to influence, take the advantage of your position. Relationship between parties, it is not necessary there is a relation, but here some sort of relation will be there, then only you can take the advantage, undue advantage. Exercised by whom? Coercion need not to be proceed from the promiser, nor it need to be directed against the promiser. It can be used even by a stranger to contract. Any person, you're walking on the road and holds you on the gunpoint and tells you, do this work for me or else I'll shoot you. So that is a stranger to the contract. Undue influence is always exercised between parties to contract. This can happen only between parties who are into the contract. Okay. Now, next is enforceability. The contract is voidable at the option of party whose concern has been obtained by coercion. If holds Mr. B on gunpoint, right? A holds Mr. B on gunpoint. So it is at the option of Mr. B. If he wants to perform the contract, he will, or else he can cancel the contract. So the contract is voidable at the choice of person who is held on gunpoint. Okay. Here, where the concern is induced by undue influence, the contract is either voidable or the court may set aside to enforce it in modified terms. If there is concern is taken by doing undue influence, court can decide or that person also can decide. If they want to perform the contract, they will. If they don't want to, they can skip the performance of contract. Okay. This was your coercion and undue influence. Let's see fraud and misrepresentation. Here in fraud, your intention is to deceive it. But here intention is not there to deceive. It happens due to misrepresentation. Knowledge of truth. The person making such suggestion is statement believes that the statement is untrue. He knows that the fact I am presenting is untrue. But here the person thinks that it is true although it is not true. Like in fraud, what happens? You know that you are saying lies, you are saying false things. Still you get into agreement. But in your misrepresentation, you think you are speaking truth, but actually you are not. Okay. Here, recession of contract and claim of damages. The injured party can repudiate the contract and claim the damages. You can cancel the contract in fraud and get the damages. Injured party is entitled to repudiate the contract or sue for restitution but cannot claim the damages. In misrepresentation, you can't claim the damages. You can cancel the contract, you can sue the other party, but you can't claim the damages. Means to discover the truth. The party using the fraudulent act cannot secure or protect himself by saying that injured party had means to discover the truth. Here party can't say that you had the ways, you can check that I am doing fraud or not. You can't say this. You cannot secure yourself or protect himself by saying this thing. Person who is doing fraud cannot say, you had the chance, you could have checked that if I am doing fraud or not. In the misrepresentation, party can always plead that the injured party had the means to discover the truth. If I was misrepresenting something, you had the ways now to check if I was misrepresenting or not. Okay, this is the major difference between fraud and misrepresentation. Generally, direct questions are very less from these topics like contract act, but if they ask you, this will be a benefit for you. Okay. Now, legality of object and consideration. When we enter into a contract, we have seen that the contract's definition includes that the objective with which you are getting into a contract should be legal and lawful, and the consideration also should be lawful. So now let's see the legality. Where there is an unlawful object and unlawful consideration in an agreement, its effect, consideration or object of an agreement is unlawful if forbidden by law. If it is forbidden by law, you are still getting into contract, your agreement is void. Defeats provisions of law. You are going against the provisions of law. Agreement is void. It is fraudulent. You are doing fraud in law. It is written that this is fraud. Still you get into it. Agreement is void. Involves or implies injury to a person or property of another. You are trying to harm any person or harm the property of a person. Agreement is void. Immoral or opposed to public policy. You are doing something which is against the public policy. Your agreement is void. Okay, your consideration and your objective should be lawful. If it is unlawful and if it is forbidden by law, defeats provision of any law, if you are doing it fraudulently, if you imply or try to injure the person or property, you are doing something which is immoral or opposed to public policy, your agreement will be void in all these cases. Okay. Now, what are agreements against public policy? Trading with enemy. You are trying to trade with Pakistan, China, Indian people. That is against public policy. Stifling prosecution, maintenance and champerty, restraint of personal liberty. You are trying to restrain someone from their personal liberty. Interfering in the course of justice. You are trying to get into the justice and you are trying to give the justice on your own. You are trying to kill people who are doing wrong. That is not right. You can't interfere. Creating monopoly, that is also against public policy. Sale and transfer of public offices and titles. You are fraudulently trying to sell the public offices and titles. Restraint of parental rights. You are restraining the parental rights from someone. Brokerage contracts you are entering. Restraint of legal proceedings and restraint of trade, restraint of marriage. You are restraining someone from doing trade or restraining someone from getting married. Okay. Agreements which are expressly declared void. Law declares following agreements to be either illegal or void. If you enter into any of the agreements mentioned over here, your agreement is going to be illegal or void. Agreements by incompetent party. You are entering into an agreement with minor or unsound mind or who is debarred from the law, who is like written in the law that you can't enter into agreement with this person. So that is illegal or void. Agreements made under a mutual mistake of fact. You are doing some agreement and you don't know the facts. That is also illegal or void. Agreements, the consideration or object of which is unlawful. You are getting into an agreement which is unlawful. Agreements in restraint of trade, you do get into agreement which is restraining trade. Agreement in restraint of marriage, agreement made without consideration. There will be some exceptions, but agreement made without consideration are illegal or void. Agreements in restraint of trade again. Agreements in restraint of legal proceedings. You are restraining some legal proceeding from happening. If a person who was a witness, you are trying to stop that witness from giving the witness, he presenting his point, that time you will be considered as getting into illegal or void. Agreement, the meaning of which is not certain. You are getting into agreement, but it is not certain that this will happen. Reciprocal promises to do things legal or illegal. If you are doing some reciprocal promises where you are going to do some legal or illegal things, that is also illegal or void. Agreements contingent on impossible events. You are betting on winning of India in the World Cup. This is an impossible event, like a contingent on impossible type of event. It can win or it can't win. Like you are doing some contingent activity. Agreements by way of wager will also be considered as impossible. Okay. So here India can win. I am just taking an example. That is not impossible event. You will get offended with it. Don't get offended. India can win 100%. Now if I go with this, we can say that Pakistan winning the World Cup in this 2024. That is impossible. They are already out of the team, out of the match, right? Out of the game. That is the impossible contingent event. Consequence of agreement expressly declared void. Agreements expressly declared void, illegal by the contractor, void ab initio. If you are getting into any agreement which is expressly declared void or illegal by the contractor, you will say that agreement is void ab initio. Okay, I hope till here we are clear. Let's go ahead and see performance and breach of contract. Okay, you can take some water break if you want. Okay, let's go ahead. Performance of contract, meaning of performance. When the parties to the contract either perform or offer to perform their promises, a contract is said to be performed. If A gets into a agreement with Mr. B that I will be performing a dance show on your birthday. So that is a promise that is done, or they actually perform that dance, then you can say the contract is said to be performed. Types of performance of the contract: actual performance and attempted performance. Where a promiser made an offer of performance to promisee and the offer has been accepted by promisee, you can say that is actual performance. A said I will dance on your birthday party to B. So that is a actual performance. Attempted performance, where a promiser made an offer to the promisee and the offer has not been accepted by promisee. He says, no, I don't want you to dance on my birthday. So that is rejected. So that is an attempted performance. A was of the good mind. He said that I will perform. B rejected. Promisee rejected. Right? Effects of the performance of contract. Actual performance, liability of promisor comes to an end with the performance of the act, and there remains nothing to be done by him. When A has danced on the birthday of B, he has completed the contract. He has actually performed it. But here in attempted performance, promisor is not responsible for non-performance and have right to claim. If he says that I said you that I'm going to perform, now you're not telling me to perform, I am not responsible for non-performance. Even if your party goes wrong, I am not responsible. You give me some compensation. Now you have to give me some gifts also. So that is, you have the right to claim. Simple basic examples I'm taking for you. Who may demand performance of contract? Promisee, legal representative, third party, or joint promisees. Promisee can demand for the performance of that contract, or your legal representative. If promisee has died, their legal representative. Any third party can ask for performance of the contract, and your joint promisees also can ask for performance of the contract. Okay. Let's go ahead. Who may perform the contract? Promisor himself may perform. His agent may perform. If promisor has died, legal representative. If legal representative appoints third person, they can perform. Or joint promisor can also perform. Any third person, agent, legal representative, joint promisor. Similar things are there in promisor promise. Okay. Liability of joint promise. A general rule: if two or more persons have made a joint promise, all of them must jointly fulfill the promise. If A and B jointly promise something to C, to perform, or like to send the goods, right, to send the goods, so here both of them will have to send them. After death of any one of them, his legal representative jointly with the survivor will perform. If A's legal A dies, right, A and B get into a contract to send the goods. A dies, so A's legal representative. A's legal representative and Mr. B will send the goods to C. After the death of the last survivor, if B also dies, so A's legal representative and B's legal representative both will get into a contract and send the goods to Mr. C. Okay, legal representative of all the original co-promisors. I hope this point is clear. You are able to recall it. Rules as to time and place of performance of contract. Cases where time is not specified, you have to do it in within reasonable time. Like if you get into contract of sending shoes to someone, 5 to 10 days is maximum. That will be that is your delivery period. So you have to get the contract done in 5 to 10 days, reasonable time. Time specified, but promise is to be performed without promisee's application during the usual business hours of that particular day. If time is specified, but promisee has not tell at this time you come, so you can go at any time of usual business hours. Time specified, but promise is to be performed on promisee's application. Time is specified that you have to come and give the goods on 2nd of February. But this promisee will tell you like today you have to come or not. On 2nd of February you have to come or not. Promisee must apply for performance at the proper place and within usual business hours. So if he calls you on 2nd of February, he has to call you on the proper place. He has to say come to Hotel Hyatt, and there you perform the contract. There you give me the goods. And at the usual business hours only you have to tell them. Now, place is not specified. Promisor must apply to the promisee to appoint a reasonable place for performance and to perform promise at such place. If place is not specified, you will ask the promisee where you want these goods to be delivered. Please tell us, we will come and deliver. Okay. Manner for performance. Promise must be performed in the manner and at the time prescribed by the promisee. If he says that I want the goods to be delivered in a bubble wrap, so you have to bubble wrap them and send it. Manner of performance, how they want. They want the delivery by road, by air, so that is also one thing. Is time an essence of contract? It is. Cases where parties have expressly agreed, time is considered to be the essence. Like when they have said that these goods are to be delivered in 24 hours only. You want to send some medicines which are very much urgent. They have to be delivered in 24 hours. So that time, your time is the essence of contract. Non-performance at the specified time results in injury. If you are not performing in the specified times, that may cause injury to the party. There can be some loss. Like if you don't deliver the medicines on time, the person may die. If he is patient in ICU, that can die. Time is considered to be essence of contract. Nature and necessity requires performance of contract within specified time. Your nature and necessity, like if you are sending milk products, they have to be delivered fresh only. If you can't deliver them freshly, then you can't say that this contract is valid. There is time is essence of contract. Consequence of non-performance within the specified time. Cases where time is essence of contract becomes voidable at the option of promise. Where time is essence, you can cancel the contract also. The contract can be voidable. Okay. If performance is beyond the specified time is accepted by the promisee cannot claim compensation for any loss. Like if performance is beyond the specified time, you perform the contract beyond the specified time, promisee cannot claim for any compensation at the agreed time unless the time of acceptance he has given a notice to promisor for his intention to claim compensation. If in the agreement you write that I will be claiming the compensation if you don't perform this contract on time, then only you can take the compensation. Cases where time is not essence of contract does not become voidable at the option of promisee. When contract is not voidable at the option of promisee, contract will be valid, you can perform the contract. That time is not essential. In that case, time is not essential. Promisee is entitled to claim compensation for any loss occasioned to him by non-performance of the promisee at the agreed time. So if non-performance is done at the agreed time, promisee can claim the compensation. Okay, because it should be specified. If you don't provide at this time, then I will be claiming the compensation. It is to be written somewhere. Impossibility of performance. A contract to do any act which after the contract is made becomes impossible or unlawful. A said that I will buy a horse to Mr. B, but the horse Mr. B was having has died. So now it is impossible to perform that contract. Okay. By reason of some event which the promisor could not prevent becomes void when the act becomes impossible or unlawful and the parties are discharged from performance. When it becomes promisor cannot do anything. He said that okay, I will give you the horse, but the horse has died now. So now that contract will become void. Okay. Impossibility existing at the time of contract or initial impossibility. If the impossibility is known to the parties, such an agreement is void ab initio. If you know that this contract cannot be performed, it is void ab initio. If unknown to the parties, such agreement is void on the ground of mutual mistake. If you don't know that this contract is impossible, then it is void. Okay. And if known to the promisor only, if promisor only knows about it, such promisor must compensate for any loss. You promised that I will give you this horse, but you know the horse is not doing well, he will die in 1 or 2 days, then why did you enter into the contract? Now if you have entered, you have to compensate for the losses. Okay, fast I am revising everything because I don't want you people to waste much of your time over here. These are the concepts you need to remember one day before. Where an act becomes impossible, supervening impossibility, after the contract is made, contract becomes void when the act becomes impossible. If you are getting into a contract which is impossible, the contract will become void. Where an act becomes unlawful by reason of some event beyond the control of promisor. Promisor also could not control the death of the horse. That time it becomes void and the act becomes unlawful. Where the promisor alone knows about the impossibility. Promisor only knows about the impossibility. That time promisor has to compensate for any loss of non-performance. Where an agreement is discovered to be void or where a contract becomes void, a person who has received any benefit under the agreement is bound to restore it. If you have already taken the benefit out of this contract which becomes impossible now to perform, like you were going, A was going to marry B, and for marrying B he had given some rupees, like he said that I will give you some money and you can keep it with you, and after marriage you can return it to me. Excuse me. So if you have entered into such contract where you have taken some money or some benefits, that time if that contract cannot be performed due to supervening impossibility, you have to restore back the compensation. Like B is not going to marry Mr. A, so Miss B, what she will have to do, she will have to give back the money which she has taken from Mr. A. Okay, because she due to supervening impossibility, she will not be able to marry Mr. A. That time she has to return it back. Discharge of contract can happen by performance, by mutual agreement, by impossibility of performance, by lapse of time, operation of law, or by breach of contract. If you perform it, contract is discharged. By mutual agreement, you say we will not perform it. Impossibility of performance, you can't perform that contract. Or lapse of time, time has elapsed. Or by operation of law, or by discharge of, by breach of contract, if someone has breached the contract. Now, breach of contract. Important concept. Where breach of contract takes place, breach of contract occurs if any party refuses or fails to perform his part of contract. If you can't perform the contract or refuse, or by your act you show that I am not going to perform this contract, that is breach of contract. Makes it impossible to perform his obligation, then it will be called as breach of contract. Effects of breach of contract: the aggrieved party is relieved from performing his obligation. The person who is aggrieved will not be performing that contract anymore and gets a right to proceed against the party at fault who has defaulted. From them you can claim the compensation. Now, there are two types of breach: anticipatory breach and actual breach. Refusal to perform the promise on scheduled date is called as actual breach. Anticipatory, you have already anticipated it. Breach occurring before time fixed for performance has arrived. Before that performance of contract would be done, you tell I can't perform this. So that is breach, anticipatory breach. Liability for damages, you can claim ordinary damages, special damages, vindictive or exemplary damages, nominal damages, prefixed damages, and damages for deterioration caused by delay. Okay, in detail we have seen all of these damages in our regular class. I hope with your books you will be able to recall it. What are the remedies available for breach of contract? You can cancel the contract, rescission. Suit upon quantum merit, you can ask for payment of the money. Then you can suit for specific performance. You can tell them now I want this contract to be specifically performed. Suit for injunction can be done. Okay. Hope there is case law only below. Let's go ahead. Special types of contract. There are few special types of contract, which is contingent contract, quasi contracts. Contingent contract means rules relating to enforcement of contingent contract, which are dependent on happening of an event. And quasi contracts, cases deemed as quasi contracts. We will be seeing them. Contingent contract is a contract to do or not to do something. If some event collateral to such contract does or does not happen. If it will rain, I will pay you 1 lakh rupees. If it rains on every day, like on every day of July month, then I will pay you 1 lakh rupees. So that is a contingent contract. It is not possible that every day of July it is going to rain. It may happen or it may not happen, right? So it is based on some collateral event, contingent event. Okay. What is essential in a contingent contract? Dependence on future event. We are dependent on raining in the entire month of July. The performance of a contingent contract is made dependent upon the happening or non-happening of some event. A contract may be subject to a condition precedent or subsequent. A contract may be dependent on happening of an event. Okay. Event referred is collateral to the contract. It is important to a contract. It is along with the contract. Collateral means along with it. The event on which the performance is made to depend is an collateral to the contract. It is an essential element of the contract in contingent contracts. Event must be uncertain. The event that you're talking about should be uncertain, right? You can't talk about certain events. You can't say that it can rain 5 times in July in Maharashtra. It rains 5 times in July in Maharashtra, but you are talking about every day it will rain in Maharashtra in July. So that is an uncertain. Contingent event must be uncertain and should not be the mere will of the promisor. Okay, it should not be mere will of the promisor. Now, some rules regarding contingent contract. Rule 1: enforcement of contracts contingent on and happening of event. It is based on happening of an event. Enforcement of contract on contingent of not happening of an event. If the event does not happen, then also it will be contingent. Contract contingent upon future conduct of a living person. If A will marry B, so that is future conduct of a living person. Contract contingent upon the happening of an uncertain specified event within a fixed time. If you get into a contract that it should rain in 2 days, so that is a fixed time. You are talking about uncertain event in the fixed time. Contracts contingent upon the non-happening of an uncertain specified event within a specific fixed time. So that was happening of event. This is of non-happening. Not raining in 2 days. Agreement contingent to an impossible event. If you're talking about an impossible event happening, that time will be, you can say that this contract is a contingent contract. Okay. Now we have the detailed explanation of each rule. Let's see. Enforcement of contract contingent on a event happening. Where a contingent contract is made to do or not do anything, if an uncertain future event happens, it cannot be enforced by law unless and until the event has happened. If the event becomes impossible, the such contract becomes void. So if we are betting on the rain, like if it rains tomorrow, then I will be giving you 1000 rupees. So it is based on the happening of event. If it happens, you will pay 1000, that will become lawful. You will be the contract will be enforced by law. If it doesn't rain, that will become void. Rules relating regarding contingent contract. Rule number 2. Enforcement of contract contingent on an event not happening. As I told you, happening if it does not rain tomorrow, I will not pay you. I will pay you 1000 rupees. So here, if an uncertain future event does not happen, that will be enforceable. Contract will be enforceable. If it happens, then you are not going to pay the money. Okay. Rule number 3 talks about contract contingent upon future conduct of a living person. Where the future event on which a contract is contingent is the way in which a person will act at an unspecified time. In such a case, the event shall be considered to have become impossible when such person does anything which renders it impossible that he should act or within any definite time or otherwise than under further contingencies. A said to B that I will marry. But before A could marry, A died. Now, here, this activity of marriage cannot happen because impossible event has happened. A has died. Okay. Rule number 4. Contract contingent upon the happening of an uncertain specified event with a fixed time. Such type of contract become void if before the expiry of fixed time such event does not happen or such event becomes impossible. If such events does not happen or it becomes impossible, then your contract will be contingent and it will not be possible. Okay. Rule 5 talks about non-happening of events, similar lines. So I'm skipping this one for now. Then we have your contingent contract, rule 6. One second. Yeah. Contingent contract, rule 6. A contingent agreement to do or not to do anything if an impossible event happens is void. The impossibility of an event may be or may not be known to the parties to the agreement at the time when they entered into it. Okay. So when if you are not aware about that impossible event and still you are getting into a contingent contract, that time it will be your contingent contract. And if that impossible event does not happen, your contract is void. Okay, I hope contingent contract is clear to you people. Let's see the next one, which is talking about quasi contracts. Okay. In quasi contracts, an obligation is imposed by law. You find a phone on the road which belongs to someone. You don't know which person it is. So you are obliged. An imposition has been done by the law on you that you have to return it to the owner upon person for the benefit of another. Who will get the benefit over here? The person who has lost the phone. For their benefit, you have to work. Okay. Then next, what they have given is in the absence of a contract. Here, no specific agreement, contract thing is done. Still, a contract arises. That is called as quasi contract. Clear? Features of quasi contracts: it is imposed by law. Obligation is a duty and not promise to party. You are under the duty. You are not promising the party. Right is always a right to money. You can always claim the money if you have found the phone. Right is available against specific person. Specific person, owner of that phone only will get the phone. Suit for breach may be filed same for as complete contract. You can also file a suit against in quasi contracts. Like if you found the phone and the person gets to know the phone is with you, still you are not giving it back, they can file a suit against you. Okay. Now, what is the difference between quasi contract and contingent contract? Let's see. Essential for valid contract. The essentials for formation of a valid contract are absent here. There is no essential elements available. But in contingent contract, all the essentials will be there. Obligation is imposed by law. This is created by consent of parties. Okay. Next that we have is types of quasi contracts. Now, Claim for necessities supplied to person incapable of contracting. You are supplying some things to a minor or unsound mind person. So that time I'll just directly start from here. Okay, these are 5 types, and we will be discussing the 5 types. Okay, first is claim for necessaries supplied to person incapable of contracting. If you are getting into a contract with a person who is a minor, you are supplying them food, shelter, etc. So you have entered into a quasi contract. If the necessaries are supplied to a person who is incapable of contracting, example minor or a person of unsound mind, supplier is entitled to claim the price from property of such person. You can tell the minor to give you the money, or their guardians will give you the money. Next is type of quasi contract, right to recover money paid for another person. A person who has paid a sum of money which another is obliged to pay, such person is entitled to be reimbursed for that. If you were not having some money and you went to Domino's, you ask your friend to pay for you. So afterwards you have to return that money. Okay, he will be obliged to return, provided the payment has been made to him to protect his own interest. This payment has been done. If you don't pay at Domino's, what they will do, they'll kick you out of the store, and they will also ask you to do some favors, like they will ask you to clean and everything, or they can file a case against you. All these things are possible. To protect his own interest, he asks someone to pay on their behalf. Quasi contracts, obligation of a person enjoying the benefits of non-gracious act. Such an obligation, right to recover, arises where a person lawfully does anything for another person or delivers anything to him, not intending to do so graciously, and such other person enjoys the benefit thereof. You were not supposed to take the benefits of it. Still, if you have enjoyed the benefits of it, you have to give it back to the person. Later is bound to make compensation to former in respect of or to restore things so done or delivered. You found the umbrella or you found a phone. Now you have filled the phone with all your photos, like 2000 photos you have taken of yours. How is that possible? You have to restore back the memory of that phone and give it back to the person whose phone it was. Okay. Responsibility of finder of goods. A person who finds the goods belonging to another and takes them into his custody, there such person is subject to same responsibility as of payee. If you are finding some goods, you have to return back those goods. Liability of money paid or thing delivered by mistake or under coercion. If by mistake you receive the parcel of your neighbor, you have to give back the parcel. What are you going to do of that parcel? You should not use it. Give it back to them. Or by mistake you received some money in your bank account. It was to be delivered to other person. You have to give back that money to the person. Okay. Or under coercion, must repay or return it. If there is coercion applied, then also if you have taken some benefits, you have to return back the money. Okay. Remedy for breach of quasi contracts: when the obligation created by quasi contracts is not discharged, you don't return the phone that you have found on the road to the original owner, then the injured party, the real owner of the phone, is entitled to receive compensation, same as defaulted party had contracted to discharge it and had broken the contract. If you would have entered into a normal contract of giving the phone, then whatever compensation, whatever liability you will have to pay, same liability you will pay in the quasi contracts. Okay. So if you are not returning the phone to the person who is the real owner and you have found the phone on road, that time the injured party, the person who has lost the phone, has the right to claim the compensation from you. Okay, I hope till here we were very clear. Contract act is clear to you people. I hope this video was helpful to you people. And this is it about the contract act. So we have revised our contract act, we have revised your LLP act, we have revised your Indian regulatory framework act. Okay, I hope this was clear to you people. That's it for the contract act video.